The zoning board of appeals open at this time. The lady on my right is Julie Beckwith. I'm Dean Beckwith. We are the zoning board of appeals at the present time. There are only two of us. First thing we do is approve the minutes of the February meeting, and if you would move to approve them, and I would second that. And
Can you turn on your microphone? Can't hear you.
I'm sorry, I don't know how. I'll speak louder. How's that?
Better.
That better? Maybe we should all just move up to the front row. I don't know. I know that the whole system is under the table here, but it's got too many dials on it for me. I'll try to speak louder though, and tell me when I'm not. Can you folks hear back there?
Yeah, we're fine.
Okay. And even though I was not present at the February meeting, you and Jack were here, I have read those minutes, and I would say I would approve them based on my experience with the January meeting. So, did I second the motion?
Yes, you second the motion.
Okay.
Can you tell us what the February meeting is related to?
The relation of this February meeting was a correction and rehearing of the January meeting.
I thought that was on January 29th, not in February.
Yeah, it was January.
That's right, but there was a meeting held in February.
Not to my knowledge.
Okay. Well, there was.
What's on the meeting minute date? What's on the meeting minute date that you're looking at?
January 29th.
Do you have one for February?
No, I do not.
Thought that was it.
I think this was the prior one.
Okay. Okay. We don't have any minutes then from February. There was a meeting held.
Okay, I can go and see if they have them.
They just won't approve them, then we better delete that from our actions when we don't have a copy of that.
But do you know what the meeting was about then, in February?
I know it was to clarify the January meeting.
The January 25th meeting is when the Township Board made their decision. January 29th, they did a reenactment of their decision on the 25th. And I don't know of any meeting in February.
Well, I was in Arizona at the time, so I can't.
You wasn't on it at the 29th meeting.
Pardon?
At January 29th, you were not at that meeting. You were in
It
Arizona.
says here on the January 29th, the purpose of this meeting is to consider the reenactment of 7 decisions made by the full board at a meeting.
Okay, I'm in error then. This is the meeting I'm talking about. Thank you.
You're
It
welcome.
wasn't in February, it was in the last day of January.
January 29th.
I knew I wasn't here and I was
Yeah.
gone in February, but I was already gone, 29. Okay.
So the last meeting minutes are approved.
We're gonna go with that with the 29.
Yeah,
I would vote yes. How would you vote?
yes.
Okay. And with only 2 members on our zoning board of appeals, to carry out anything, we have to both vote in the affirmative, because our third member, there is no third member anymore, so. If we split votes on something, then it's no action. Okay, thank you. Now, to today's business. We are gathered for the interpretation of zoning ordinance. Ken has provided us with a document with 62 requests in that, and that is what is before us today. It's our task to interpret always the zoning ordinance. Now, having reviewed this document, I find that there's simply a restatement, and I should say a restatement in many more words of the original January hearing.
I agree, I feel that it's a rehash of the January 25th and the 29th.
I'm gonna make an objection to that. I'm gonna base my objection on the fact that the document that you're looking at with 62 questions is a document that goes to the township that is related to asking the townships before the hearing to admit, deny, or claim they have no knowledge to those, so that when we come to this hearing, there is a clear thing. The failure for the township to answer a request for admissions within 28 days requires me to ask them to answer again between that. I did that. So I have submitted a motion to you today that you are working on talking about right now I gave you a motion and a brief to deem the facts admitted against the Columbia Township for failure to comply with the rules of Michigan court rules, which says that if they don't answer in 28 days, I have to ask them to answer, and then before the hearing can start, you have to decide if you're going to determine that the answers are all in the affirmative, and that would be your first action. By law, you have no choice. If they didn't answer in 28 days, say all 62 of those questions are in the affirmative. So that's before you right now. There are actually a few things I'd like to make sure that you have into your evidence today. One is going to be on February 15th. I sent a written request to the ZBA to hold a hearing on 6 questions. That would be this document here. The 6 questions are, does the ordinance allow the natural origin of such other than most 50% of the products that can be sold on a farm market to be subject only to the sole discretion of the farm market owner? That's one of the questions. The second question is the ordinance meaning of the farm market as defined in the farm market GAMP synonymous with and equivalent to the farmer's market as defined in Public Act 100. That is not a previous question you were asked. No one brought both those to you. No one brought, has the ZBA decision rendered in an ordinance equivalent to the meaning of the farm market defined in the farm market GAMP and the farmer's market GAMP is defined in Public Act 100. Have you brought that into the zoning ordinance to say that a farmer's market is a farm market and anyone in a farmer's market can do what the farm market does, when they're totally two different definitions by state law? A farmer's market is a group of farmers that gather, like in South Haven, to sell their produce at a great big government sponsored event. Whereas a farm market is where a owner or a farmer or a farmer's operator has direct contact with their customer to sell their produce at a roadside stand. And the GAMP has modified that to allow them to make a farm market, which allows them to sell 50% of their product at the farm market, that they can enhance that farm market product with taking their strawberries and making strawberry pie, or taking blueberries and making blueberry pie, or other items in that section, apples, peaches, pears. And then the GAMP says, if allowed by local, and when they say that, local ordinance, state law, or federal law, they can sell other items in the nature of retail or activities on the farm. And our ordinance has done that. And they've listed a lot of activities, but none of those activities are alcohol. And what your zoning ordinance says, in section 1.04, it states that if an activity, land use activity, is not a permitted or is allowed by special use, it's not listed, then it doesn't, not allowed in our township. So there is no alcohol in our zoning ordinance for the ag district, because section 1.4 says that if it's not listed in there, you can't do it. And that's what I'm trying to get across to here. I'm trying to get the law portion of this, taken care of and settled by the ZBA. Does the ordinance allow Public Act 100 of 2013 defined as a farmer's market as a permitted principal use? It's not listed there. There's no such thing as farmer's market there. I don't see how they can. The fifth question I had is, does the ordinance allow sampling of wines and hard cider as a permitted principal use of an ordinance compliance with a farm market conforming to the farm market GAM? In other words, really, we always say is for the use is that you can use the GAM. But the GAM doesn't give them the right to do everything without local, state, and federal if it's outside selling their own produce or enhancing their own produce. And my sixth and final one is ordinance section 1.04 with respect to the sale of wine and hard cider at an ordinance compliance farm market conforming to the farm market GAMP does not, the farm market GAMP preempt the ordinance regulation prohibiting such sales, which basically is taking you to the point that since we haven't got a farmer's market, how can you be selling wine and hard cider if the only person that can get a license is a small qualified winemaker? So those are the 6 questions I have. Back previously, where you said you've already heard this, said, does Columbia Township zoning ordinance allow farm market in the agricultural district to sample and sell alcohol? You used a memo that was never provided to me until you sent it to me on January 26th, and that memo is the 12/14. Pardon?
I never sent them.
You attached it to the determination of the zoning board of appeal. And it's a Hudson's memo. And in Hudson's memo, he said he used that act to justify the sale of alcohol in a farm market in the agricultural district, which personally I believe is rezoning the district. Did the ordinance violate or occur when Stokes Farm Market sold alcohol beverages at the farm market in the fall of 2005? You said no violations, because I'm not asking now about the violation. I'm asking what the law says. I'm not talking about a violation. Did the zoning administrator properly issue a notice of violation? I don't say anything about issuing a violation there. Did the zoning administrator improperly consult with the township attorney? I don't talk about the township attorney being consulted. Did the township attorney have the authority for the zoning enabling act to make a final administrative decision? I don't say anything about that in my 6th question. Did the process of making a final decision to the administrative question violate the Open Meeting Act? I don't say anything about the Open Meeting Act. And the last one was, did the public official or employee willfully neglect to perform their duty when allowing a non-permitted use to occur and took no action to stop it? Again, I'm not saying anything about that on this. What I have done is I have sent you 6 questions that relate to the legal aspects of being able to do what's being done in the township, in the ag district, that are basically, I gave you all the law. When I sent this, I gave you the section of 3.04. I gave you section 104. And I gave you all the documents that you would need to go through. I defined the Right to Farm Act and what it means. I highlighted the sections that talk about it. I talked about farm product, process of farm products, the general accepted agriculture management practices. I talked about the farm market as defined by the GAMP, which is a transaction between a farm market operator and the customer.
I got that packet.
Pardon?
I got that packet.
That is what we're here today for. Before we can get to this, after I did this, when you get into a process like this, the sharing of information between who I'm having, I don't want to use the word argument, disagreement, but I'm in disagreement with. What happens is I submit the request. Then I need to submit my evidence that goes with my request, which I did when I submitted the request. The township would respond back to me with their evidence, and then we would both come in here. We could meet together. Him and I could have sat down and said, okay, I agree with you this, yeah, you convinced me on this, we get it down to a real small little piece of pie that we can discuss in front of you, that we disagree with, so you can make a decision. There is no communication from the township to me of what their argument was gonna be, so I've had to do a request for admissions to see where they're at, what we might agree with, what we might not agree with, and what they did is fail to answer. And when you fail to answer in 28 days, by law, court rules, I have to tell them that they didn't answer. Your job is if they don't answer, you can order them to answer that document. Unfortunately, you have to do that before you get to this hearing. So if they don't answer, the first thing at the hearing, I had to provide you a motion and a brief, which is what you're looking at, 62 questions, and you have to determine if you are gonna deem the facts that submitted against the township for failure to comply by answering within 28 days, if you're gonna make my request an omissions in the affirmative to all those questions for the failure to answer. And by court rule, by law, you have only one choice, and that's to say that they're admitted.
Okay. Any other comments?
If you're going to make a decision, and I would like to make sure that you have all my evidence, and that
We'll
it gets
attach it
entered.
to the minutes if you want to give us a copy of.
Well, I've already given you a copy. I'm not gonna give you any new evidence. Everything I've done, I've given to you, but I sent with proof of service on February 15th, a written request for a hearing before the ZBA. I put in a request for admissions on May 30th with proof of service to the clerk.
What is that called, did you say?
It's a request for admissions, petitioner's first request for admissions.
Okay.
On July 15th, I provided you with a motion to deem the answers in the affirmative, which is a motion and brief to deem the facts submitted. I did that with proof of service on July 15th. And with that submittal to the township clerk, I also provided a copy of a opinion from Attorney Owen Ramey. It's an independent opinion stating that only a winemaker or a microbrewery can obtain a farmer's market permit from the Michigan Liquor Control Commission. And that will be this document here. Dean, I think you have a copy of it. So if you're gonna rule to dismiss this based on whatever, I need to have all that information in the record.
We'll do it, got it down.
Okay?
Okay. Any other comments from folks? Okay, well, I've listened, as everyone has, to Ken's history of his interaction with the township. Still come to my interpretation is that the zoning board of appeals cannot hear or vote on an issue that has been dealt with 2 times before by this board. I think it's impossible for us today to take any action. In fact, I think that the state of Michigan says the zoning board of appeals cannot hear question twice. And I say that fully understanding that Ken is saying, well, it's not the same issue. But in my mind, it basically is the same issue. And I think that,
I agree.
that you would agree. So.
Which of those 6 questions have you answered before? You didn't answer those 6 questions that he
say
just
we
know.
did.
Huh?
I'm saying this hearing today.
No, he submitted a request for, that you to interpret the zoning ordinance based on 6 questions. You haven't addressed those 6 questions in
That's fine.
January,
We
February.
don't have to, we're addressing.
Yes, you do.
The appeal.
No, his
That's
request
your
was
opinion.
for you to interpret the zoning ordinance, all right, based on those 6 questions. You're not doing that.
That's your opinion. Thank
No,
you.
that's not my opinion, that's fact.
Okay. Mr. Hudson, do you have anything to add to this?
Well, I'd like to say for the record that I've never had a hearing on the questions being presented before the ZBA today. I never knew about the Hudson's draft memo that he used at the 25th hearing. At the 25th hearing, I objected to you having that hearing and not providing me a fair and impartial hearing. I had not filed an application, I did not have a fee paid at that time, and I wasn't provided any files from the township, which is required to be submitted to the ZBA immediately. I FOIA'd that, you never had his file sent to you, and it's supposed to be shared with the other party, which would have been me. It wasn't shared with me, so I was never given an opportunity to be heard at that previous meeting that you're talking about. Therefore, you made a biased decision by one party coming before you, and you could contact 2 attorneys and get their schedule to work to get them here, but you couldn't work with the petitioner's schedule. So again, for the record, I've never had a hearing on this issue.
Have you got that spelled out in that document?
No, but I can send you what I just said.
Okay,
I got good share of it.
okay.
Good. I would also ask you to reconsider your decision that you just made. Based on what I just told you. I have never had a previous hearing because I never was allowed to attend.
I don't think that's quite accurate. You were allowed to attend, you did not attend.
But I objected to you having the hearing because I couldn't attend, and you made another hearing at the same time where I still couldn't attend, and you never, I requested a scheduling meeting so that we could schedule a hearing well in advance, so that I could be able to get someone to take my position at work. And you could have made it early in the morning instead of in the afternoon when I have to be at work.
I think we made that second one because of your request.
You never asked me about the date, you made it the same time and the same day the following week, which again is on my work schedule. And everybody here knows when I work.
We understand that you're opposed to this and
Yes.
disagree. So note that, and you want this included in our minutes as what you just said there in that last?
Yeah, I was never given a previous hearing, because I wasn't allowed to come at a time that you guys kept giving without asking me, can you make it? I'm sure you asked the 2 attorneys, can you make it on this day? Does this work with your schedule? Never asked the petitioner. You have to, they got big, busy schedules, just like I do.
You used to.
Pardon?
You used to. Now you're retired.
No, now I can be here any day you want.
Okay. Hearing no further discussion, I think we'll move to action of the board. And I would say, I wrote this down, so I would say it the way I want to say it, is that we cannot hear and vote on the same issue twice. Therefore, today's hearing is invalid and no action can be taken. The reason for this is to hear an appeal a second time would be illegal for the state of Michigan law. And we've already included the fact that Mr. Spicer is in disagreement with that.
I'd like to add one more statement to that, Dean, is that you 2 can't hear. That doesn't mean the township board couldn't appoint 3 other members to the ZBA to hear it because they wouldn't have heard it.
At any rate, having ruled in the moment here, if we vote on this, know that I think that this was said early on, that the next action called for is to take the issue to a circuit court. and it be decided by someone other than this board. At any rate, I would entertain a motion to, a motion to, close our meeting because it's not able to deal with the, issue a second time.
Okay, I'll second that one.
Moved and seconded, thank you. And how would you vote on that? Yes, no, yes,
Yeah,
yes,
yes.
and I would vote yes. Okay,
I would like to note that I object, and I'm asking for another reconsideration.
I noted that, thank you.
I'm after that motion though. Every decision you made, I want to have an
Oh, I
objection
see.
and reconsideration.
Okay.
Okay.
Okay. Thank you all for coming.
Dean, you have to have public comment after we close, otherwise they'll get you on the open meeting act.
I don't know if it's accurate or not. I
Public
just,
meeting,
I
right?
can't hear you, sir.
I don't. Are there any public comments? Okay, Frank.
Now, I personally don't think that we should, have liquor in an area that you got farmers at farmers market. And I'm strictly against that. And the only reason I don't like the idea is they were asked, whoever wanted it was showed that we had it in our ordinance, and they seem not to give a damn about our ordinance. So I just don't see why we are on in black and white for everybody to see, and we're spending all our money on this situation where it should never happen. It should have been just, no, you can't have it, that's it. Now they wanna change the ordinance so everybody could have liquor on the premises.
I think you're arguing to the issue that's not really before us here today.
Well,
issue
no,
before us,
I'm not arguing, I'm just, my public comment.
All right,
That's-
your public comments are not aimed at what we're doing this morning. I understand your questions and your comments, but the issue before this board is, can we hear an appeal a second time? And the answer is, no, we cannot. Now, we can argue all day
All
as
right.
to whether it's actually a second opinion or a third
All right,
opinion.
then
or
I'll
something else.
I'll change it. I was at both meetings that you were approving, and at both meetings, it wasn't done proper to me when the lawyer is telling you what to do. The lawyer was telling you, you gotta answer it this way. Well, you answered it wrong before, then we had to change it, and then we had to do that again. And then you change yes to a no, from a no to a yes, and, I mean, that's not a meeting, that's not what it's all about. I was there, and I don't think it was done properly.
I've been involved in this for quite a while, and I've gone through quite a few of the papers, not all of them yet, but I will. And I don't understand why the Board of Appeals and our county board seem to feel that they are above the law. Ken has provided documentation showing the law positions of law, but why does the Court of Appeals feel that they can, or the Board of Appeals feel that they can run over the top of the law? They can't. That's what the law is made for, was for the general people. Now they're saying they want the, community to expand and be, more monetarily approving. Well, first of all, let's get the taxes, adjusted for these people that have businesses in the area. Let's not, let, the tax money will go into the township and will help out a lot as far as roads and other things go. They need to be adjusted, and let's abide by the law that we have. That's why we have the law. That's all I have to say.
Thank you.
What was your name? Pamela Bradbury.
You signed the attendance sheet, is that correct? You signed the attendance sheet?
Yes, I did.
And I apologize for my voice, I should keep that.
That's all right, I don't have my hearing aids in, it's my
Well,
fault.
I have mine in and I'm loading one. No, I just know it's a problem for me, but probably others. Other comments? Thank you. And really, folks, we're ruling that the decision was already made, so we cannot hear it a second time. You can question the ruling as you are the first time,
Yes.
but that is not before the zoning board of appeals today. And the only way a person can, as I understand state law, is to take this now to circuit court and say, here's what the zoning board did, and here's this and this, and all the documentation that Ben has there. And I appreciate all that documentation. But
Ben,
that's
Dean,
not the
Dean,
issue
Dean,
before us
why
right now.
didn't the court, why didn't you folks vote on this properly in the first place? Why didn't you look at the law and absorb it and vote on it as the laws are stated in the state of Michigan, and which apply to counties as well as the state? Why didn't you do that?
I certainly thought we did,
Okay, you thought we did,
yes. I
but,
believe that I did, or I wouldn't have done it the way we did it, so you can argue with me and argue
I'm
that
not
point.
gonna argue
But
with you.
that is
I
just
just want this
what
out.
we did, and based upon what we knew, we felt that was the decision to make. And we made
Even
it.
I knew that it wasn't the right way to go, and I'm not an attorney, even I knew that.
Okay.
So, and I'm just an ordinary person,
And
who's
here,
learning more about the law.
and here we are spending more money because we're gonna go to court now.
I understand that,
You
Frank.
know, and I just, it just overwhelms. I mean, there had 7 different court cases, all 7 were won. I don't understand why we're gonna do another one, which would be 8. It's just spending money. It's ludicrous. I mean, it's so simple, it's there, and it's not being acted on. I mean, it's just,
Anyone else?
Yes. Yes, the purpose of this ZBA hearing, all right, was a request by Mr. Spicer for the ZBA to interpret the zoning ordinance based on 6 questions. You didn't address those 6 questions, all right? They are not related to any decision back in January, all right? They are 6 individual, independent questions, all right, that you are asked to interpret, that, to clarify the zoning ordinance. You didn't do that. All right, you deflected this, basically saying that it's a second, you already made a decision on those 6 questions. That's what you're basically, essentially what you're saying. All right, you did not address these 6 questions.
I thought there were 7 questions.
7 questions, excuse me, I can't count.
Excuse me, there were 6 questions that I presented to you, there were 7 back in January 25th.
These are separate
2016.
individual questions of ordinance interpretation, which you are not addressing in this meeting. You're failing to do that. You're aware of that?
Now, we know that we know what we just did, yes.
Okay, all right, well.
All right, you've taken action, is that correct? You voted not to hear?
No.
Pass that motion not to hear this?
Yes.
Okay. Any more further comments? I would call the meeting adjourned.
This is what I read to you about, this is the 25th and 29th, 7 questions that you had. These are the 6 questions I have today, and I read you the black stuff on here. But that should go into the record because you need to, I read that to you.
You know,
In other words, your meeting, your minutes aren't gonna be able to do that, you might want to just attach it. The other thing, this right here is what I stated, about the draft Hudson letter. And this is what I said at the end that I object to the ZBA for not providing a security that I have not done business this evening. So, and this stuff should go in your meeting minutes, you probably won't just. Okay?
Okay, man, and welcome.
No, the guy.
Well, that's fine. I thought Hudson was here, but they didn't have any
They
comment.
didn't say.
You wanna email it?
They asked him if he had anything to say, he just shook his head. No.
I'll send it back and say.
But he was present.
Okay.
I can't tell.
Yeah, that's good.
So when I get it, I'll tell you I received it. Fair? Thank you, Dean.
Thank you.
They should have.
Just like the old west.
Right, and then, maybe not, maybe.
You can't hear it twice, you can't hear it twice, you should have 3 others.
And,
They should have alternates, so you can go without 3 main members and alternates to fill in for situations just like that. So